Catherine V. Latinid, and today my topic is all about Article 1200 to 1201. So, what is Article 1200 all about? Article 1200, the right of choice, belongs to the debtor unless it has been expressly granted to the creditor. The debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been object of obligation. So we have here our example. Three debtors got a loan from Marino and bound themselves to pay 2,700,000 pesos. The loan was secured by a mortgage of house and lot. It was agreed that if upon the maturity of the debt, the debtors are insolvent, they would cede the house and lot to Marino. If the house and lot would not be sufficient to cover the debt, the balance would be secured by the mortgage of 4 parcels of land belonging to one of the debtors. The titles were delivered to Marino. As the debt was not paid, Marino sued the debtors. So the question is whether or not the stipulation of the parties is valid. Yes, this stipulation is valid. It is simply an alternative obligation which is expressly allowed by the law. The agreement to convey the house and lot of an appraised valuation of the event of failure to pay the debt in money, it is maturity, is, however, in our opinion, perfectly valid. It is simply an undertaking that if the debt is not paid in money, it will be paid in another way. As we read the contract, the agreement is not open to objection, that the stipulation is a patio commissorio. It is not an attempt to permit the creditor to declare the forfeiture of the security upon the failure of the debtor to pay the debt of maturity. It is simply provided that if the debt is not paid in money, it shall be paid in another specific way by the transfer of the property in a valuation. Of course, such an agreement unrecorded creates no rights in rem, but as between in parties, it is perfectly valid in specific performance. Performance by its term may be enforced unless prevented by the creation of superior right in favor of the third person. So next is Article 1201. The Article 1201 is that choice shall produce no effect except from the time it has been communicated. So we have here the effects of choice or selection. Number one is the obligation will be limited only to the chosen or selected prestation. Number two is the choice of irrevocable, otherwise the party might be exposed to damages which may arise from a costly preparation in writing of the performance of the announced recitation. So the performance of is not binding and the debtor simply performed his choice of presentation without announcing it to the creditor. The debtor can recover what he had delivered, performed, or paid under the law of quansi contracts. The law grants the debtor to make the choice unless the creditor is expressly granted the said right. When making the choice, the law does not require that the choosing party first secure the conformity of the other party, because that will only frustrate the clear intention of the law and the alternative nature of the obligation. So what the effects of delay in making selection? The delay in making selection does not constitute to losing the selection. However, if before any choice is made, a case is filed in court, an issue may arise regarding the presentation that will be enforced. The code is silent on the point of who will make the selection, although there are three possibilities. The court will make the choice, the court may order the debtor, or the creditor will make the choice within a certain period. The right to choose belongs to the debtor. If he does not do so, the choice can be made for him by the creditor by applying the principle of Article 1167. So we have here again our example. A building is a plaintiff was insured against fire by the defendant in the sum of 30,000 pesos, as well as the goods and merchandise therein contained in the sum of 15,000 pesos. The house and merchandise insured be burnt, while the policies issued by the defendant in favor of the plaintiff were in force. The plaintiff filed a case against the defendant in the reason that the defendant wanted to just rebuild the burnt house instead paying of the plaintiff amount that was insured. The lower court rendered a judgment in favor of plaintiff, sentencing the defendant company to pay him the sum of 45,000 pesos, the value of certain policies of fire insurance. The defendant appealed from this judgment and now insists that the same must be modified and that is must be permitted to rebuild the house burned, and then that the appellant be relieved from the payment of the sum in which said building was insured. In the instance case, the record shows that the appellant company did not give the formal notice in its election to rebuild. And while the witnesses spoke of the proposed reconstruction of the house destroyed, yet the plaintiff did not give his assent to the proposition of the reason that the new house would be smaller and of materials of lower kind than those employed in the construction of the house destroyed. The Supreme Court did not find any merits that would justify the reversal of the finding of the trial judge. The decision of the lower court was affirmed with the cause against the appellant. So the issue in here is whether or not the lower court erred in the decision in favor of the plaintiff. So no, the judgment appealed from was in accordance with the merits of the case and the law. The Supreme Court affirmed the decision of the trial court. So that's it for today. Thank you.